Hey guys, this is Roxann Smithers with Smithers and Ume-Nwagbo, your trusted 360 General Counsel, and this is a note from my Legalpad. I have many mantras that I live by. One of them that definitely epitomizes my work as an attorney is that lawyers love paper. So we're going to talk today about why lawyers love paper and how important documentation is. So when a client reaches out to me and they're excited about a new opportunity that's coming their way and they want my advice, they want my help in how to structure this new business venture, one of the first things I'm going to ask them for is the contract, the terms of the agreement, any communications between the parties, any documentation. Likewise, if a client comes to me with a problem and we need to resolve a dispute, we need to enforce their rights, we need to respond to a demand, the first thing I'm going to ask them for is the contract, the communications between the parties, and any documentation of the relationship and of the dispute. So whether a situation is good or a situation is troubling, lawyers love paper, lawyers love documentation. There are a couple different ways that you can memorialize your relationships, both when things are going well and when there's a problem with a business relationship. The Cadillac of ways is a written contract that is signed by all parties that addresses the relationship in total. The second best way are email, written communications between the parties, either laying out the potential terms for the agreement, laying out the obligations, agreeing to certain facts, putting forth offers, and exchanging information. Meeting notes are also a great way to memorialize a situation as parties are meeting to talk about, okay, how we're going to move forward in this relationship, what are the issues in this dispute, what are the offers or the counter offers that have been exchanged. Taking notes during a meeting that can be utilized later to make sure that everyone's on the same page or to refresh your memory when we're trying to piece together either a deal or piece together the dispute, those are important as well. I will even take text messages. Even though I generally advise clients to refrain from conducting business and exchanging substantive information through text. If that has occurred and if there are communications via text, you want to make sure that you archive, save, download, print those text messages so that they can be utilized down the road. We ask for all of these types of written documentation in addition to maybe photographs or video if there is an area or a product or a situation that really needs to be conveyed visually versus being conveyed through words. That's the other piece of documentation that we want to make sure that we have. So you may be wondering, how do lawyers use those items? So if I am putting together the deal documents for a client, maybe there's a new business venture, guys have met, you've talked through the issues, you're very excited, then we want to make sure that we can put together in writing the framework and the roadmap for how that relationship is going to move forward. That happens in your contract, in your scope of work, in any other exhibits or documentation that's necessary and that would go with that contract. And so having those emails where you've talked about the terms, talked about pricing, discussed the scope, or having those meeting notes will help me to build that contract. Similarly, if there are models, if there are drawings, if there are photographs that are going to be key to those obligations or the rights in that contract, we want to have those things as well. On the other side, if I'm looking to resolve a dispute, or heaven forbid, we have to enter into arbitration or litigation with regards to a matter, your documentation are the tools. They're the weapons that your attorney uses to go to battle on your behalf. The stronger that arsenal is, the more varied that arsenal is, the more contemporaneous to the time of the dispute that arsenal is, the better equipped we are to advocate for you in litigation or arbitration and get the type of desired result. You have to remember that individual memories fade over time. Witnesses may leave town and may also decide that they don't want to participate, or may have ill feelings with one or both of the parties and not necessarily want to give helpful or favorable testimony if we have to wait in order to hear directly from them. But having letters, having emails, even having text messages, recordings that are collected and produced during the time of the dispute that document the issues, those are the types of tools and pieces in an arsenal that are very strong. Invoices, receipts for payment, receipts that you have received products, the condition of those products. Those are all the types of paper and documentation that will strengthen your case, that will support your personal testimony, and that will help us to show a third party finder of fact, either an arbitrator, a judge, or a jury, that your version of the events is the true and accurate version of the events, and that the remedy you're seeking is fair, reasonable, and supported by the facts. And so I have these conversations with clients about the best ways to make sure you are getting that documentation. If you're a person who loves a face-to-face meeting with individuals, that's fine. Make sure that you take notes during that face-to-face meeting, or you take notes during that phone call, so that you've got your impressions, you've got a little bit about the subject. If there are key points or admissions by either party, key things that y'all agreed to, make sure that you note those things. Another thing that I love is the follow-up email. I send dozens of emails that say, following our call, following our lunch, following our video chat, we discussed A, B, and C. I have agreed to provide 1, 2, and 3. You have agreed that you're going to do LMNOP, and we're going to circle back with each other by this date. Laying out everyone's expectations in a follow-up email is an excellent way to make sure that everyone's on the same page and to flesh out any disputes or any issues at the time. If the person then replies, yes, we're on the same page, and there's a dispute down the road, you have a powerful tool that you've provided to your attorney. If they don't respond and they don't correct something, again, you have a powerful tool that you can provide to your attorney. The next thing, of course, the most formal, is to have that written contract that's negotiated and agreed to by everyone. And that's ultimately what we're going to want to have in place at the end of the day. Because if there are questions or concerns in the future, the contract is the roadmap. When you are meeting with individuals to pursue opportunities, when you sense that you're entering into a dispute or the parties may not be seeing eye to eye on how a relationship is progressing, remember, your lawyer loves paper. So make sure that you provide them as much paper as possible. If you'd like more information about the attorneys with Smithers and Ume-Nwagbo, you can find us at stulawgroup.com on Facebook, LinkedIn, and Instagram. Be sure to like this video and subscribe to this channel so that you can get the latest notes from my Legalpad.